last but not the least, for the inaugural session, our speaker. Finally, we have an expert in the domain of data protection and the 5G-led digital economy. We did speak about the protection of the data as well. Please join me in welcoming Dr. Pavan Duggal, Chairman of the International Commission on Cybersecurity Law and Advocate at Supreme Court of India. Dr. Pavan Duggal has had a significant influence on the developing fields of cyber law and legislation pertaining to e-commerce throughout his more than 20 years of practice as an advocate in the Supreme Court of India. Without further ado, please put your hands together for Dr. Pavan Duggal, who's the founder and chairman of International Commission on Cybersecurity Law. Sir, a very warm welcome, and please join us on the stage now.
Good morning. When the room is full of legends, you feel dwarfed. But it's a great learning moment as we talk about the various aspects of this ecosystem. As a legal student, I believe that there are certain things that I want to bring on to the table, which I think every stakeholder in the 5G plus ecosystem needs to well understand. First, that there's going to be a massive increase of terror and cyber criminal activities on this 5G plus ecosystem. So apart from all your technical challenges, you will have bigger challenges of how to deal with cyber crimes and with cyber terror. On top of it, 5G fraudsters will actually be ruling the roost, which effectively means that these very fraudsters are going to go ahead and create the new 5G fraud economy. No wonder when Prime Minister Modi says it's a 5G era and we have to be 10 steps ahead of crime world, he's bang on target. Why? Because Indians are phenomenally expert and fertile in understanding this. And when I map it with the growing ransomware attacks, I am not surprised. In the first half of 2023, we've seen a twofold increase as far as ransomware attacks have been concerned in the Indian ecosystem at large. Well, everybody knows about 5G, so quickly we'll quick this off. My scenario is advantages are massive, but it's an ecosystem, it's a paradigm that we talk of. I'm also concerned about the disadvantages, because these disadvantages are going to be harnessed into illegal and criminal activities on the network as we go. But when I talk of this 5G plus data economy, no wonder data will be the major fuel in this new data economy of this 5G plus. So how would you know as a 5G player what kind of data you are dealing with? The earlier speakers talked about monetization of using intelligently the data. But then how do we land up taking this forward? And when I'm just dealing with data, how do I know whether it's normal data, whether it's personal data, whether it's sensitive personal data? Because everybody in the ecosystem would be bothered more about speeds, would be bothered more about the new paradigm as we go forward. So the issues of data protection will have to assume massive significance on this new 5G ecosystem. Well, prior to 11th of August 2023, life was a different ball game altogether, because we did not have anything on data protection. But then we already had the global standard, which was the General Data Protection Regulation of the European Union. But by and large, while some companies were complying with it, there were still not major compliances. So this has to be seen in the context of what's been happening quietly in India. The concept of privacy, well, the Supreme Court in Justice Puttaswamy versus Union of India has been holding crystal clearly that your right to privacy is an integral part of your right to life as you go forward. But then when I talk this 5G plus data economy, how do I deal with data privacy? How do I deal with personal privacy? And what can be done? So when Justice Chandrachud talks about privacy as a constitutionally protected right, which emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution, he's bang on target. Privacy safeguards an individual's autonomy and recognizes the ability of the individual to control vital aspects of the life. It's in this context that I now want you to wake up, because this new law has come up, the Digital Personal Data Protection Act 2023. And I can promise you one thing. There's been no other law which India has passed which is going to have so much of a humongous game-changing impact as we go forward. We've had a long history, 5-6 years of deliberations, new drafts, and finally, India has come up with this new legal framework. The issue is that this law appears to be very simple, but this law can potentially have the massive advantage of foxing you at any point of time. And therefore, the first thing we need to know is this law is going to deal with personal data. Good news is the law has been passed. The good news is equally better that the law is still not implemented. But the not so good news is that the law is going to be implemented soon. And the government is working on the rules and regulations of this law. So it only is covering personal data. So when I'm a 5G plus ecosystem stakeholder, how do I know what kind of data is floating on my network? And what can I do? Okay? The law says, wake up. Why? Because the law has come up with 3 distinctive concepts of data principal, data fiduciary, and the data processor. All of us, to whom our data belongs, are data principals. That's understood. Anybody who determines how my data is going to be processed becomes a data processor, data fiduciary. And somebody who actually processes data becomes a data fiduciary, a data processor as well. So first things first, we are now doing something that we haven't done ever earlier. We are effectively going to ask for ijazat. We are going to ask for consent of the data principals by first giving them a notice. The notice will have to be given in writing, saying, sir, we would be collecting your personal data. Sir, this is the basis and the rules why I want to collect personal data. Please give me permission, give me consent. All this will have to be written. No verbal, no call centers, no audio. It's all verbal written. It's all going to be written. And then the concerned person will have to give you your consent. If he gives the consent, no problem. You can process, otherwise not. The problem now is, they've said 250 crore rupees is going to await you as a fine if you don't comply with this provision. And this 250 crores is a per contravention exercise. So, I'll end up doing 3 contraventions. I could potentially be fined up to 750 crore rupees. And this is a continuing thought process. So imagine in the 5G plus ecosystem, when there's so much of data flowing, I have no clue of what kind of personal data is floating, when, where, how. I, as a data stakeholder, will have twin exposures. I will both be a data fiduciary, I'll also be a data processor. Sometimes, depends on which side of the spectrum I'm looking at, I would be seen as a data fiduciary. Others, I will still be seen as a data processor. So either way, my exposure is on. So what does that mean? This means that the government will now have a new stream of revenue. This money of 250 crore rupees is actually now going to go in the coffers of the government in the form of Consolidated Fund of India. And everything will really depend on how they will implement this. But please understand, in this 5G plus ecosystem, you will have a Damocles sword that will be waiting for you. It can drop on your head at any point of time, because 250 crores, I think, is enough for any small, medium, or even a bigger company to start winding up their operations as we go forward. So bottom line is, I think stakeholders will have to tighten their belts. We will have to create new structures on this 5G plus ecosystem. How do I, as a stakeholder, determine where is the personal data originating from? Have I given written notice to the concerned data principal? And if so, have I taken written consent? In our country, every person steals. The man who gets caught becomes a thief. We will have to make sure that we have the appropriate written permissions and consents of the data principals as we process the data. Otherwise, just be prepared for 250 crore rupees. Now, this 250 crore rupees is unprecedented because we have never seen this kinds of fines ever been put in the context of the IT ecosystem. Well, under the IT Act, the 2000 law, we just had maximum of 1 crore. Under 2008 amendments, we had 5 crores and unlimited liability. But we never got a lot of these crores actually being awarded. But now 250 crore rupees suddenly is one paradigm that we have to wake up. So I think the focus will have to be more on legal due diligence. When you are coming up with these new services, please protect your bank. Why? There was nobody else who's going to protect your bank. And this is the message that this new personal data protection law has actually come up. Also, the question is, due diligence parameters are going to be defined by various rules and regulations of the government. So we'll have to wait and watch what things are. But complicating the entire scenario is this factum that the data principal can call upon you at any point of time and say, hey guys, I want to revise, review, amend, delete my data. I want to have the right to erasure of my data. So in this 5G plus ecosystem where things are moving at such fantastic speeds, how do I ensure that I give the right to erasure of personal data to a user? I think that's where the industry will have to start working quickly and coming up with appropriate parameters. Good news is there are no offenses defined under this law. That means you can't be sent to jail. Okay? But the bad news is 250 crores. So it's a 250 crore versus not going to jail. But the bottom line is, this is still a half of the picture. The real picture is that this civil liability has been enhanced to 250 crores. The criminal liability nonetheless continues under the IT Act and under the IT directions. So it's a 360-degree coverage that you are getting covered in. You are being sucked into legal liability, civil and criminal. Civil liability is under the DPDP Act. The criminal liability continues under the IT Act and the rules and regulations made thereunder. So bottom line is, whatever you're doing in this 5G plus data economy, please ensure compliance with the applicable laws. If you don't again do that, there will be problem. Have proofs, documented proofs. The next time there's a knock on the door, you get a summon from the Data Protection Board of the country, you want to come up with documentation to show that you have complied. But the problem is, the government has also said, I'm going to create two bubbles in this ecosystem. There will be first the corporate bubble, where everybody will have to comply. And the government has been given the power for exempting certain governmental agencies from the applicability of this law. So there'll be a second bubble where these governmental entities will not be required to comply. So there's bound to be an intrinsic conflict tension between the bubble of the corporate sector who has to comply and the bubble of the governmental sector who will not comply. So I don't know how this actually will work, but if you're not going to be satisfied with anything, any order passed by the Data Protection Board, the law says you will now be given an opportunity to go in appeal to the TDSAT, or the Telecom Dispute Appellate Tribunal. The good thing is the law says, even before you get that 250 crore rupee hit, please use the alternate dispute resolution mechanism. Go in for mediation, go in for conciliation. Try to find out where you can remedify and avoid this 250 crore rupee fine. So alternate dispute resolutions are being given primacy. Of course, you will be heard. You will not be condemned unheard. So if 250 crores have to be awarded against you, you will be given an opportunity of being heard to the concerned Data Protection Board of the country. Good thing, the data protection law is not a special law, which means it doesn't override other things. The not so good thing is, it says, well, vis-a-vis data, anything that I say becomes paramount. So already we find this unique problem when there are intrinsic conflicts that are going to be happening under the IT Act and the DPDP Act, because the IT Act is a special law, this is not a special law. And mind you, for the first time in the history of the country, we have two laws defining data in two different manners altogether. So the IT Act defines data in one particular holistic manner. The DPDP Act actually defines data in a different manner. So there's going to be even conflict in how this data is going to be looked at. Vis-a-vis RBI, who has said the banking data of Indians within India, I think there's going to be a challenge because data localization has been given the complete bye-bye under this new law, which means that banking data could potentially go outside the country. Of course, the government will have the right to exempt the RBI from such a scenario. Also, the government has taken out your right to seek unlimited damages under Section 43A of the Information Technology Act 2000. So that's one remedy that you will now no longer have. But because of this intrinsic conflict between the IT Act and the DPDP Act, you're going to see increased enhancement of litigation I see now tsunami of litigation coming in with this new DPDP Act coming in place. So be prepared. In whatever ecosystem that you are in this 5G world, you could potentially be exposed. I'm not an astrologer. I can't predict when you will be sued. But the chances or the probability of you being sued is going to be relatively very, very high. More so when the law is intrinsically talking in two different directions, both under the IT Act and under the DPDP Act. The good thing is that we have tried to customize data protection in the context of India. The not so good thing is that we have not learnt much from the general data protection regulation of the European Union. So with the result, we have not still imbibed large number of those parameters which have been an integral part of the GDPR in the European Union. But that is all it was referring to a pre-30th November 2022 paradigm when the chat GPT of the world had not arrived. Chat GPT has come in, it's changed the complete paradigm, and now, because its APIs are open, every day you see flooding of AI products, AI algorithms. In a scenario like that, when you are going to use generative AI in the context of this particular 5G data economy, how will you ensure that the personal data of data principals are going to be protected? Because Indians, by the way, are vomiting all kinds of, shall I say, Indians are vomiting a lot of personal data on these generative AI platforms. And without realizing that these generative AI platforms are collating your data. Read through the terms and conditions and privacy policy of OpenAI. Your eyes will be open up to say, well, wow, I have no privacy. Yes, you have no privacy. And if you're going to merge these kinds of generative AI programs with the 5G economy, it's bound to create a problem. Of course, the problem is we still lack clarity. So a lot of this clarity could be coming in the form of new rules. Government has said they are not waiting for elections. So I'm anticipating before the end of this year, we should have these rules and regulations coming up in the context of the DPDP Act. The problem is this law does not talk much about cybersecurity. We don't have a dedicated law on cybersecurity. The DPDP Act does not talk about cybersecurity. And the only thing it says is, hey guys, you as data stakeholders will have to put in appropriate technical and security mechanisms for protecting personal data. What will that be is something that we'll have to still wait and watch as we go forward. So for cybersecurity, please realize this Data Protection Act alone may not suffice. You will still have to comply with reasonable security practices and procedures defined under the IT Rules 2011. In addition, because you will be in the 5G ecosystem, you will still have to ensure compliance with the IT Act and rules and regulations made thereunder. So I think it'll be imperative if we can actually, with the passage of time, make this law more consumer-friendly, more customer-friendly, more corporate-friendly. Because right now, there are huge gaps, huge gray zones in this law as we go forward. When I compare this law with the General Data Protection Regulation, I find we are a very, very light version of the GDPR. But even this light version to be implemented in India is going to be a challenge. Because in a country, when in a railway journey, when you are going, you are actually knowing far more about your co-passenger. We have actually started living through this social sharing times. Only in the last about a decade or so, people have become more conscious about their privacy. In the context of 5G plus, I'm not so sure how this is actually going to evolve. But, well, I'm seeing a scenario when there'll be a conjunction between 5G plus and Web 3.0. And once that happens, how do you protect personal data? Big questions. I don't have answers. But I think when we begin starting asking questions, we have 50% of the job done. So bottom line is, don't play with fire. You're going to jump into a big well of fire. Please wear a good firefighting suit so that when the flame comes in, it does not burn your skin. So please go ahead and do documented compliances, due diligences, because that's your only step forward. See, the Indian law is pretty much inspired by our mythology. So when I looked at the Mahabharata, and when I read through the Gita discourse, Bhagwan Krishna talks to Arjun and gives one central message. And the message is, hey Arjun, come to my Sharana. and I will protect you. This Indian law, whether it's the IT Act, whether it's a DPDP Act, have a similar message. Hey guys, come inside my parameters. I promise that no harm will befall upon you. You don't comply with me? No problem. That's your funeral. Play with fire as we go forward. So due diligence, caution, care will have to be your only mantra. And in addition, while we are all talking about data protection law, please don't forget about the Indian Information Technology Law, the cyber law, because it still continues to be the mother legislation for everything in the electronic format. Finally, 3 areas that I would want to highlight before I leave. Please ensure compliance with the Digital Personal Data Protection Act 2023. Otherwise, be prepared for 250 crore rupees fine per contravention. Number 2, please ensure compliance with cyber security directions of 2022, because they have said you will have to report every cyber breach, a cyber security incident or a cyber incident within 6 hours of coming to know about it. You don't report within 6 hours, you actually commit an offense, punishable under section 70B of the IT Act with imprisonment and fine. चोरी सारे करते हैं, जो पकड़ा जाए वो चोर कहलाता है. तो अगर आपने अपनी कोई भी साइबर सिक्योरिटी ब्रीच इस 5G इकोसिस्टम में नहीं रिपोर्ट करी पता होने के बाद, तो आपने ऑफेंस कर लिया. अगर ऑफेंस कर लिया तो अगले 7 साल तक इंतजार करिए. क्यों? क्योंकि गवर्नमेंट के पास लॉ एनफोर्समेंट एजेंसीज के पास 7 साल का समय है आपके बरखिलाफ केस दर्ज करने के लिए, आपको प्रोसिक्यूट करने के लिए. So here is a second big thing. I want all of you to avoid your potential exposure to criminal liability, because that, apart from anything else, will have a huge reputational ramification for companies as we go. And finally, I will just say, please ensure compliance with the Information Technology Act 2000 and the rules and regulations made thereunder. Please ensure there's more building of appropriate capacities, because that's the only way forward. They have come up with a law. We don't know when the law is going to be actually used against you. But if it's going to be used against you, your capacity building is going to be a good step going forward. So I started creating an experiment. I created this platform called cyberlawuniversity.com. I said, I'm in cyber law. Who would be interested in cyber law? I came up with 37 courses online. And I've been surprised, in the last about 5 years, we've seen about 29,500 professionals from 174 countries who've done these courses. So these figures are telling us that there's a need for massive capacity building. And before I close, I would want to invite all of you to this big conference that we do every year. This is the 10th year, the International Conference on Cyber Law, Cybercrime and Cybersecurity, 29th, 30th November, 1st December. PG has been a part of this conference from the word go. It's the 10th year, PG. Time really flies. That's wonderful. But this year we are focusing on rise of emerging technologies and their impact. And the supporters throughout the years have told us one thing. Guys, don't sit back and be complacent, because technology is a great master. It constantly keeps on telling you, hey guys, please go ahead and update. So the only message for the DPDP Act is, guys, wake up out of your deep slumber. The new legal framework has come in. It could come and impact you any point of time. Please wear a good fire suit before jumping into fire. Thank you, ladies and gentlemen.